Hello and welcome. Of course, as alluded to on your screen, this is the Ontario Stay-at-Home Order for Law Enforcement. I am, of course, Brian Lass, and I do welcome you wholeheartedly to this presentation, which admittedly comes somewhat at the request by way of numerous phone calls I've been receiving from law enforcement officers here in the province, in light of the perhaps somewhat perceivingly confusing landscape that is our current COVID enforcement landscape, if I can use such language here in the province. So again, for those of you who are a little less familiar with me and perhaps my relevance to the requisite subject matter. Formerly, I am POA prosecutor with Go Transit Metrolinx, having appeared regularly in 11 plus jurisdictional branches of the Ontario Court of Justice, as well as former executive member of the board with the Regulatory Compliance and Enforcement Council, which found me more or less playing host as POA instructor to countless regulatory and provincial agencies, enforcement agencies to that effect here in the province. So again, I do welcome you to this presentation. Now, albeit, of course, the requisite subject matter, the stay-at-home order, which unto itself is a regulation under the Emergency Management and Civil Protection Act, I will tell you that although we'll be talking about the EMCPA and certainly the Reopening Ontario Act as well, we won't necessarily be taking a deep dive into the shall and shall nots, i.e. the succinct, meticulous details of exactly what these different sections of these different acts and regulations say, but rather what we're going to be looking at is an overview of the enforcement landscape and how we sort of arrived at where we are present date and how we may endeavor to actually applicably enforce what the current state of the legislation is. So without any further ado, let's get right into it. And certainly a relevant question, where exactly does our journey begin for the purposes of this presentation? Well, quite frankly, perhaps the best place to begin is with a brief history of COVID measures here in the province of Ontario. So certainly if we go back in time, of course, to March of last year, 2020, which is when this whole pandemic sort of came to be, if you will, and more succinctly, March 17th, 2020. Of course, the province is as well as the premier to that effect, as you can see on your screen, declared a state of emergency here in the province. And of course, recently we have done this for a second time, more on that in just a moment. But certainly the province did this by way of utilizing their ability under the Emergency Management and Civil Protection Act, or EMCPA as we know it as. And certainly and arguably so, for many of us in the law enforcement community, this was, at that time, the first time we had ever heard of an EMCPA, let alone actually look at this act. But certainly, as you can see on the bottom portion of your screen, 7.0.1, Declaration of Emergency. Of course, it was in the Premier's opinion that this pandemic or this coronavirus landscape was urgent enough to declare this emergency, but perhaps more relevant to us, indicative on this slide here. And this section at the top of your screen, 7.0.2, that number may sound somewhat familiar to us, especially those enforcing the current COVID enforcement landscape currently. But obviously, in declaring the state of emergency, the Premier of the province, they declared what was referred to as emergency orders, certainly for protecting the health, safety, and welfare of the people of Ontario. And the way that they sort of enacted these emergency orders was in the forms of regulations under the EMCPA. So again, although we use this language, orders or emergency orders, really these were just a succession of regulations, which seemingly still to date and always changing and seemingly never ending, as far as change goes, landscape in regards to the pandemic here. So, to that effect, obviously at that time, in regards to all these different emergency orders, this was enforced under the EMCPA, the respective offenses, these short form wordings here, and namely that of perhaps item 1, for someone failing to comply with an order made during a declared emergency, i.e. these different regulations that were passed, the shalls and the shall nots that we heard the Premier talking about seemingly every day or every other day. Now, to that effect, if we certainly fast forward to July 24th of last year to be exact, the province enacts the Reopening Ontario Act. Now, that being the longer title there, we simply know it perhaps in the interest of timeliness as the ROA, Reopening Ontario Act. And certainly a relevant question can be posed here. Why did the province decide to do that in light of, enforcement started out under the EMCPA? So why was the Reopening Ontario Act enacted? What was the relevance? And really the sort of short answer is that the ROA is of course we come to know it as the Reopening Ontario Act, is it acts solely specific, obviously, to that of the COVID-19 or pandemic landscape here in Ontario. So basically what happened and how we sort of switched over, if you will, to all things to do with the ROA was that, if this hand's indicative of the ROA, if you will. Basically, we had gathered, and we being the province and enacting the ROA, gathered all the emergency orders, or i.e. regulations under the EMCPA, and basically placed it under the umbrella of the ROA. And we continued on still with these emergency orders, these regulations being active, being, good, if you will. But again, we've just endeavored to sort of enforce these under the ROA, and certainly indicative of this slide right here, taking right from the Reopening Ontario Act that talks about the orders continued. So certainly the orders made under section 7.0.2, which we talked about a few slides ago, under the EMCPA, have not been revoked, but again, they've just basically been placed under the ROA to continue on with enforcement under the ROA, and certainly that was happening, basically from the end of July onwards, and still relevant to this day, as sure as I'm sitting here making this video as well. Now, as far as, endeavoring to enforce these regulations that were now placed under the ROA, obviously the offenses now created under the ROA for that purposes as well, which we can see on our screen, still very valid to this day. Basically, anyone failing to comply with what was referred to as a continued section 7.0.2 order, or in other words, the emergency orders that started under the EMCPA and now carrying on under the ROA. And again, this perhaps made a little bit more clear in the interpretation section of the ROA, talking about what a continued section 7.0.2 order means, basically reiterating what we just mentioned a couple seconds ago. So with this landscape at the time with the ROA, certainly we saw all sorts of different variations as far as, the regulations under the ROA were concerned. We talked about stage 1, stage 2, and stage 3. We had all these different color schemes, things of that nature. And then, of course, ultimately, at, mid-December, December 14th, 2020, everyone went into what was known as this gray lockdown, if you will, the whole province. This was spoken about more rightly so under stages of reopening, OREG 363/20 under the Reopening Ontario Act. And again, what does this really translate into? The entire province, basically had to abide by what we refer to as stage 1, or perhaps more specifically, rules for areas in stage 1, which unto itself was a regulation 82/20 under the Reopening Ontario Act. And that basically brings us to sort of the here and now, and with respect to this stay-at-home order. So certainly, as we know, and as it relates perhaps to the stay-at-home order specifically, of course, recently Ontario has announced a second declaration of emergency, much in the same way that the province or the premier did at the onset of this pandemic last March. And basically in doing so, again, as we know, this is done under the EMCPA. And to be a little bit more meticulous, this is the actual declaration of emergency itself from July 12th of this year, 2021. Again, just talking about the second state of emergency, or declaration, another declaration of emergency, if you will. So in doing this, and, certainly as many of us probably got to our phones, this emergency alert talking about the stay-at-home order, again, under the EMCPA, as far as any further emergency orders are concerned, well, we do have an active emergency order, if you will, this stay-at-home order, which unto itself is a regulation, OREG 11/21 under the EMCPA. So what does this mean? Well, it means that the stay-at-home order is enforceable by way of the EMCPA. Now, we're looking at this, at least the first part of the stay-at-home order right here. So a couple things to take note of, just in the interest of best navigating this. Certainly as far as the definitions are concerned, in this stay-at-home order, albeit under the EMCPA, it does make reference to that of a stage 1 order. So certainly, what does that allude to if you read this verbatim here? Well, it's talking about the rules for areas in stage 1, so i.e. this current landscape as prescribed by the Reopening Ontario Act. So it's almost like a dual landscape, if you will. And to that effect, one other thing at the bottom of your screen to take note of, as far as this, true essence of the title, I suppose, stay-at-home order, or requirement to remain in residence. So every individual shall remain in their place of residence at all times, unless leaving their place of residence is necessary for one or more of the following purposes, and certainly as you go through the act, as it plays through here a little bit quickly, there are a lot of perhaps excuses that one may endeavor to offer as far as having allowability to not be in their residence. So certainly you'll want to go through this. It's not necessarily the longest regulation, but as it weighs applicable to your specific tenure, obviously you will want to sort of take a closer look and compare it to the landscape that you work within. For example, maybe a bylaw enforcement officer like you see on your screen. But to that effect, as far as enforcement is concerned, as far as the stay-at-home order, again, this is going to be under the EMCPA and under these, short form wordings, which have changed a bit as recent as January 14th. The Chief Justice at the Ontario Court of Justice approving these short form wordings. So, of course, we have individual fail to comply with the order made under declared emergency. We have a separate caveat for a corporation, but again, all indicative of the same section, section 7.0.11, subsection 1. And to that effect, certainly speaking to that of the EMCPA, if we look at the long form wordings, albeit on the last slide, we saw some prescribed fines. You can see here as underlined and bolded, there are some very hefty set fines should you commence a proceeding by way of Part 3 of the POA. So, still somewhat on the topic of, these enforcement of COVID-19 measures or the actual regulation that speaks to this under the EMCPA. Speaking specific to this world of the stay-at-home order, again, there is this requirement to identify, which, isn't necessarily new news. It's come up prior under the EMCPA and certainly still the case under the Reopening Ontario Act, but let's look a little bit more closely at this. Now, you can see on this slide, certainly we have an officer saying ID please, a person saying, are you charging me? Well, this is, to be honest, a valid question for the reasoning of how the long form wording plays out of this requirement to ID. So, as far as a would-be defendant perhaps having a requirement to identify the officer, provincial offenses officer, police officer, as you endeavor to read this in full, the short version is that, he or she has to have reasonable and probable grounds to believe that an individual has committed an offense under section 7.0.11 of the Act. So in other words, basically is in breach, if you will, of the stay-at-home order. And in having that reasonable and grounds, at that point, the officer may require the individual to provide the individual's correct name, date of birth, and address. So again, it's not that they have to hand over photo ID, but just, of course, have to provide, valid credentials, if you will. And certainly, as the wording goes, probably indicative of the fact that, again, the officer has to have these grounds of this offense before they would make the request for the ID. So again, in the absence of those grounds, you can't make the request. So this very much alluding to the idea that, the ID is going to be for the purposes of charging this person, because here is an officer with grounds of, again, a breach of the stay-at-home order and applicable to enforcement under the EMCPA. And again, what I will reiterate here, in perhaps a different set of words, if you will, is that the officer cannot compel a person to provide any information further than what's written above in section 2, subsection 2 above. So again, we can't ask for ID for the purposes of determining whether or not someone should be perhaps where they are at the time we're investigating them. No, the ID is specific to the idea that we already have grounds of a breach of the stay-at-home order under the EMCPA, and now we require that ID for the purposes plausibly of charging this person. And again, the same goes for, as I've already alluded to, that of under the Reopening Ontario Act. So what we're looking at right now, not to muddy the waters, but this is the enforcement of orders as far as the Reopening Ontario Act is concerned. Very much similar wording in that the officer does first have to have grounds. So again, does have to provide that ID, again, only if the officer has the grounds and is endeavoring to charge a person. So, with that being said, there is, of course, no arrest authority under the EMCPA. However, this is a big however, again, should an officer have grounds of this person before them, would be defendant, having breached the stay-at-home order, as for example, under the EMCPA, the officer now is trying to, satisfy ID of this person for the purposes of charging them. If push does come to shove, if I may use that terminology loosely, it may be the case that this turns into a circumstance of obstruct peace officer, which of course under 495 the criminal code, obviously there's an arrest authority. So it may be the case that, in light of this person obstructing the officer, not providing the ID as required, a legal duty to act and not acting, if you will, it may be the case that this is, the avenue that the officer endeavors to go down. But again, of course, this is certainly a very much a last resort. And the one other thing I will say, certainly you'll want to be careful if this, if this sort of, comes out of an investigation. Again, all of a sudden now we have an arrest with obstruct, simply for the reason, of course, under the Canadian Charter, obviously Section 9, everyone has a right not to be arbitrarily detained or imprisoned. And the reason I bring this up, you want to be very cautious that, if you do arrest a person for obstruct, what tends to sometimes happen is the officer will then say, to this would-be perhaps accused at this point, you know what, I'm going to cut you a break. I'm not going to, pursue the obstruct charge, the criminal charge. I'm going to, cut you loose on that. However, I'm still going to issue you perhaps a provincial offenses notice or provincial offenses summons for the respective EMCPA offense that sort of started this whole investigation. But again, for all intended purposes, obviously at that point, you have released this person unconditionally. However, what could sometimes happen is this person still sitting there in handcuffs waiting for you to basically write up this summons or ticket, explain it to them, and then release them in the handcuffs and issue them that summons or tickets. But of course, from the point you actually tell them you're not dealing with a criminal offense, to any later point, this person should not be in handcuffs. I mean, jeopardy certainly has changed, but not to an offense that has an arrest authority. So you want to be very cognizant about this plausible violation of this person's charter rights. And, certainly, again, what is going to be advisable if you do arrest this person for obstruct, as far as how you're going to release them, you obviously won't want to release them on an appearance notice for obstruct peace officer, along with, perhaps subsequent to, releasing them actually from handcuffs, issuing this Form 9, if you will. Obviously, you're going to want to then, subsequent to that, issue either the POA, you will issue a POA summons returnable to the same, a date, address, location, if you will, of the appearance notice for obstruct, and you're going to do that in regards to the EMCPA charge. And again, as you're looking at the top part of your screen, the Supreme Court judgment in RV Skaska does stand for the proposition that the provincial court judge does have jurisdiction to hear POA and summary conviction matters together. Of course, obstruct is a hybrid offense. The Crown can elect to proceed summarily, so certainly that's how we're going to want to resolve that. Now, as far as some additional enforcement measures, still under the guise of the EMCPA in light of the stay-at-home order, of course, we talk about the idea of temporary closures. This perhaps being more applicable to, let's say, organizations such as the, AGCO or maybe municipal licensing and standards that are dealing with certain caveats, or businesses that, the premises are open like they shouldn't be. They have too many people in there when weighed against the respective, regulations, as, for example, under the Reopening Ontario Act, and certainly the idea of perhaps Adam's Barbecue comes to mind, not to start a whole new kerfuffle with that. But again, this being applicable perhaps to the tenure and the landscape you're working within, but again, provided for under the EMCPA. And to that effect as well, there's an order to cease attendance or disperse. So again, this speaking more so to, public gatherings when there's more than the allowable amount of people gathering together. Certainly, the officer would have the ability to, disperse these individuals should they not want to disperse. So, perhaps it's the case that a charge, being that this again is another enforcement, order, or another emergency order, if you will, under the EMCPA. It may be the case that a charge is warranted. Now, moreover, and with that mouthful having been said, certainly, as I've already alluded to a couple times, the orders currently enforced under the Reopening Ontario Act, are being extended. That's certainly still the landscape. There's still enforcement under the ROA as it was, for argument's sake, prior to this new stay-at-home order. Certainly, as far as the ROA is concerned, again, as I've mentioned, we are currently dealing with the landscape of rules for areas in Stage 1. And as such, should we find anyone in violation as to what is prescribed by Stage 1, and certainly it's lengthy, you'll want to look at it meticulously as it applies to your respective enforcement tenure. Again, that's the caveat as we're looking at the bottom portion of your screen, short form wording offenses that we will endeavor to commence, again, should we find someone who is not abiding by the rules for areas in Stage 1. So really, in essence, being that we've talked about the EMCPA and ROA, certainly there are two landscapes, if you will, in constellation with each other that are to be navigated. That, of course, being the Reopening Ontario Act and Emergency Management and Civil Protection Act. So with all that being said, certainly with a little bit of a historical, overview leading to where we are right now, this brings us to our ending point. So certainly I would, like to extend my thanks, respect, acknowledgement, and appreciation for all of you out there, especially in uniform, endeavoring to navigate the otherwise muddy waters that are, really the COVID enforcement rules and regulations currently in the province here. And to that effect, that is it for today. So I thank you so very kindly for joining. Bye-bye.